a non-freehold estate, such as a term for years, correct, is defined in the same concept, in the same way that waste is defined for purposes of a life tenant. Remember, a life tenant cannot commit waste. Why? Because there's a remainder person, right? So therefore, you cannot waste the property because somebody else has a future interest. So let's talk a little bit about when we say a tenant has a duty to pay rent, a tenant has a duty not to commit waste, right? What are we talking about? Well, there are three kinds. Actually, there's four, but in general, when you look at commercial outlines, they talk about three kinds of waste. We got four. And what are those? What are the types of waste? Voluntary waste, permissive waste, ameliorating waste, and involuntary waste. Okay? So again, when we say a tenant has a duty not to commit waste, correct? What we talk about is in terms of these four things. What is voluntary waste? Is the tenant is liable anytime he acts in such a way that the remainder value of the property is diminished. Diminished. What would be an example for that? You are renting a house in land that is wooded, right? And you go out and you remove all the trees in the property, and as a result of that, the value of the property diminishes. What you have done in there is you have committed voluntary waste. You are allowed to use the resources of the property to maintain the property. So if it's necessary to cut some trees down so that the rest of the trees continue growing, you can do that. If you want to cut down the trees so that you can use that money to repair the roads, you can do that. You're not liable for that. But in general, any use of land which diminishes the value of the property, any act that you commit that diminishes the value of the property is voluntary waste. You have a duty to maintain the property in repair. You cannot just not mow the lawn. You cannot just not fix the windows. You have to maintain the duty to protect the property from slipping into disrepair. If you allow property to slip into disrepair, you have committed permissive waste. Now look at the difference. Voluntary, permissive, right? Let's look at it technically. Permissive means, voluntary means what? You voluntarily did something that allowed the property to be diminished. On the other one, you didn't do anything. You simply stood back and did what? Permitted something to happen. That's the difference between voluntary waste and permissive waste. In one, you are committing an act that will reduce the value of the property, right? In the other one, you're not committing an act. It's almost like affirmative easements and negative easements, right? You're not doing anything, but you're standing by as watching the property fall into disrepair. So that's permissive waste. Ameliorating waste is different. Ameliorating waste means you didn't particularly did something that reduces the value, but you did something that changed the nature of the property. Right? You bought the lot with a house, and now you are going to build a boxing range in there. Right? This is different than, wasting resources. This is different. In that case, ameliorating. Now, here's the difference. Under the traditional common law, you committed ameliorating waste whether the value went up or down, didn't matter. You were not supposed to change the nature of the property. If you rented a house, you maintained it a house. Right? If if you rented a barn, you maintained it a barn. If you changed that barn and you built a boxing ring, and as a result of that, the property value went up under the traditional common law, you still committed waste. It wasn't a matter of increasing value or reducing value. It didn't matter. You did something. You wasted the property. You changed the purpose for which you got the property. Whether it increased or decreased didn't matter. You changed the purpose. Under modern law, the only time you're liable if it reduces the value of the property. That's it. If it increases the value of the property, you are not liable for damages. So let's put them together, and then we'll take a break, and we'll start with assignment, delegation, and concurrent ownership. You cannot commit waste, meaning you cannot go out and waste the resource. You cannot go out and do anything that is going to reduce the value of the property, such as cutting trees, digging for minerals, unless the digging for the minerals is to maintain the property. That's called voluntary waste. You cannot sit back. If I get cancer because you pointed that thing at me, those X-rays. If you sit back and you let the property fall into disrepair, right? You haven't done anything, still you're committing waste because what? That's ameliorating waste. If you change, permissive waste, I'm sorry. If you change the nature of the place, you are liable if, by changing the nature of the place, you have reduced the value of the property. Only if you have reduced the value of the property. Are you liable if a third party commits damages? If a third party comes in and destroys the property, are you liable? Under the old days, the life tenant was not liable, was liable. Why? Because since the remainder didn't have a stake in the property yet, what they had was a future interest. The remainder could not sue the third party. They couldn't go to court. They didn't have standing. They couldn't go to court and say, I'm the holder of a future interest, and I want to stop this third party, these neighbors, from coming in and hunting in the land, because as a result of their cars going around, they're making tracks, they're killing the trees, they're killing the vegetation, and the value is reduced. They couldn't do that. So, the person that they could sue was the life tenant, not the third party. Correct? Under modern law, new rules and permissions allow now remainder man to sue for waste. Therefore, now the life tenant is not liable for actions of third parties, not liable for involuntary waste. Let's take that concept and apply it to landlord-tenant. Just like the life tenant, the life estate holder, the tenant is not today liable for actions of third parties, because the landlord can now go. You can't, whatever. Of course, we talked about insurance. We talked about risk of loss, right? Who needs to cover insurance? If you want to protect your property, a landlord is only insured for the outside. Landlord is not responsible for your personal property, so the tenant is liable to go to get their own rent. Right? Let's take a little break now. I was going to, and this is going to be hard, Terry, because I'm going to let's do assignment and subleases. Right? Here is landlord, tenant, T1. Right? Now, if you look at this, it's eerie how familiar it looks to covenants, doesn't it? And there's a reason why it looks so much like covenants. It's not that it's eerie. It is a covenant. That's why it looks like a covenant. And this is something I usually like to teach easements and covenants before I teach landlord-tenant, right? Because when you're teaching landlord and tenant and you start talking assignments of leases, students do not see. They forget about it when you're dealing with covenants, right? And now we can be a little bit more understanding because I think we understand easements and covenants. If I have to point to somewhere I think our class is strongest, and I think it's the easements and covenants. I saw you guys studying harder for that than I saw you for anything else. I'm concerned about the land transfer with you folks, but this, covenants you did very well. So here's what we have. We basically have an agreement between a landlord and a tenant, right? It's a covenant. What is a covenant? Landlord says, I will give you an apartment that's habitable without my interference, right? I will give you an apartment where I will maintain the common areas, correct? A tenant says, for that I will pay you rent. I will not commit waste. I will protect my personal property. I would, that's what the tenant says. That's the covenant. Landlord promises some things. Tenant promises some things back. Those are covenants, right? So let's just concentrate on because, contrary to what I heard from other places, you can have a tenant that is both in a covenant, have a burden and a benefit, right? The burden is to pay rent. The benefit is the right to enforce the promise of the landlord to provide habitable premises. So you can have a landlord that is both the holder of a burden and the holder of a benefit. So when you do covenants, easements and covenants, and you have to decide whether something runs with the land, you have to first decide, are we talking about the burden or are we talking about the benefit, correct? Having said that, let's simplify this for our purposes and let's use the duty to pay rent. Let's concentrate just on that. That's a burden, correct? Just do that. Let's start by saying this. The covenant to pay rent runs with the land. It runs with the land. Correct? In general, it runs with the land. So, the question is this. Since the tenant agreed to pay rent, what if the tenant, if somebody else comes into the picture, who has to pay that rent? And the difference here is whether we have an assignment or a sublease. A covenant to pay rent does not run with the land. I say generally, if it's a sublease. A covenant to pay rent runs with the land if it's an assignment. And the key for that is going to be the concept of privity of estate. Correct? When, a landlord and a tenant are both in privity of contract and privity of estate. Let's just simplify matters. Who is in privity of estate with the landlord? The last person that's in the property. That's the person in privity of estate with the landlord. In our landlord-tenant relationship, right here, if there hasn't been an assignment or a sublease, correct? Who is the last person? The tenant is the last person that has a property. That's why the tenant is in privity of estate. Right? Now, we don't need to get into what privity is. We understand. It's a legal relationship, right? It's a relationship, right? Now, what liability arises here depends, again, if it's an assignment or a sublease. What's the difference between an assignment and a sublease? In an assignment, you give away everything that's left. So if you had a 5-year lease and you decide after 1 year to have somebody else move in for you, and the agreement is that person is going to take over the lease for the next 4 years, which is what's left. That is an assignment. If I'm going to be gone only for 1 year, and I will return, and I find somebody that's going to move into my apartment for only 1 year, that still gives me 3 years left. 1 that I was there, 1 that I'm gone, 3 after, right? That is a sublease because I only gave 1 year. You are moving out. And in fact, one of you just spoke to me about it, right? You have a month-to-month lease. But during this summer, you're going back to Georgia. Right? You're from Georgia.
Alabama.
Alabama. Much better. Don't say anything bad about Alabama. You know, if somebody moves back to Alabama for the summer, but they are going to retain that month-to-month. She wants somebody to move in. Let's not make it month-to-month that complicated. Suppose she has a year lease, right? That begins May 31st. And she decides between July 1st and August 31st to have somebody else live in her apartment, but she will return in September. That is a sublease. Why? Because that only took 3 months out of the whole year. So she's subletting. That's important, again, because as far as liability is concerned, right, subleases do not run with the land. Right? Assignments do. And we know that for this person, the subsequent person, just like it is in easements, right? For this person to be bound by the agreement between these two, the covenant must run with the land. Right? If it doesn't run with the land, this person is not liable for the promises made by these two. Use contract principles. In contracts, in general, right, a third party cannot claim or be sued for a breach of the original parties unless new thing added recently is a third party beneficiary. Generally, on the traditional contracts, this person, right, acquired no rights, no liabilities, because they were not part of the contract. Now, we have the concept of third-party beneficiary. In property, we don't want to use the concept of third-party beneficiaries, so we use covenants running with the land. That's our third-party beneficiary business, kind of, because we're going to see something later on third-party beneficiaries. Now I can say this. Once there is an assignment, correct, it runs with the land. Now we say that T1 and L are in privity of estate. Right? Now remember the first time I told you that privity of estate? You all were like, well, I don't understand this. And I came up with the easy definition of the last one in there as privity of estate. Let's be a little bit more legal. When we use this in landlord-tenant or in covenants, in landlord-tenant, what we say it is, this one is in privity of estate because there was horizontal privity and because there was vertical privity. That's why they're in privity of estate. If I would have said that to you the first time we had landlord-tenant, you would have gone, huh? Right? Now, why is there privity of estate? Of course, even in England, there's privity of estate between this one because even in England, a landlord-tenant relationship was considered horizontal privity, right? Even in England, which was very limited, didn't have instantaneous privity, right? Why is there vertical privity between these two? Obviously, there's a transfer of property. There's a legal relationship. So, and that fulfills almost every jurisdiction. For the benefit to run a law, for the covenant to run in equity, it does for everything. Why? Because there is both. As long as you have both horizontal and vertical privity, there is not going to be any exceptions. Every jurisdiction is going to admit that there is responsibility from T1 to K. Right? So T1 continues to be liable, not because T1 entered into the original contract with the landlord, correct? But because she is in privity of estate. On a sublease, the covenant doesn't run with the land. What does that mean? There's no vertical privity. Doesn't run with the land. There's no vertical privity. Therefore, there's no privity of estate between the landlord and tenant one in a sublease. Correct?
Yeah.
There's no privity of estate. Once the tenant assigns or sublets, does that relieve the tenant of liability? Well, it's easy to say in a sublease, of course not. Because in a sublease, right, you only gave away a little portion, so common sense tells you, you still got to be liable. Because you didn't give away everything, right? It's harder to understand that on an assignment because you gave away everything. So why should you, since you turned over everything, correct? Why should you be liable? Because you had a contract. And the only way you are relieved, and this is contracts again, the only way T is relieved of any responsibility from the landlord is if that initial contract is what? Replaced, novation, torn down, a new contract is signed, all those things that you're learning in contracts about how to terminate a contract, right? That's the only way that this is. So if you have a landlord-tenant question in which the landlord and the tenant, right, agree that the landlord is going to enter into a new lease with the assignee, right? And that new lease is going to, of course, contain different terms, new consideration, correct? If that's what the problem says, in that case, T is what? Relieved. Release. And now, there's a contract, new contract, so therefore, there is privity of estate as well as privity of contract with T1. But that only occurs in the event where there's a novation or a new agreement, which is a novation. So far, so good. So what do we have? T1 is liable for rent in an assignment. Unless tenant enters into a new agreement or T1 enters into an agreement with the landlord. Right? On a sublease, there is no privity of estate. Therefore, the tenant 1, since there's no privity of estate or privity of contract with the landlord, tenant is not, T1 is not liable to the landlord for any rent. However, he is in his land. He is a trespasser. So therefore, the landlord has the right to evict. All right, let's stay with the assignment. What happens now? This one said, I'm going to take it for the next 4 years. After 1 year, decides I'm going to assign it to T2 for the last 2 years. All right? For the last 2 years. Does that change the dynamics? Well, as far as T is concerned, no. I haven't said that T built any new contracts, rescinded the contract. There was an innovation, right? So T, even though you have T1, T2, T3, T5, T6, T7, T8, T100, right? T is still what? Liable. Still liable. Unless, again, there's a new contract. Right? The problem here is, how about T1? You see, T1, remember, was not in privity of contract with the landlord. Was he? So, the only reason T1 is liable is because T1 happens to be in privity of estate. But now, T1 passed the property to T2. At this moment, correct, T1 is not sharing the land. Who is the last person in the property here? T2. So therefore, the only one that's in privity of estate with the landlord is who? T2. If there's only one person that can be in privity of estate with the landlord, what does that mean? T1 is not in privity of contract, and T1 is not in privity of estate. So therefore, once the property goes to T2, T1 is out of the picture. But T1 is not out of the picture as to the time that T1 was on the property. So let's say that after 1 year, he paid 0 rent. And then he assigned it to T2 for the next 2 years. Is he liable? Yes, he is. He's liable for that 1 year. Now, again, don't make any judgments about the test. I'm not talking to you about the test. But in the past, understand this because Professor Otis King and his questions will remain. He used to ask questions in which the yearly rent was $10,000, right? And after 2 years, he assigned it to T2, right? T2 didn't pay for 1 year, and then assigned it to T3, who didn't pay for the next 2. What's the amount of money T1 is liable for? What's the amount of money T2 is liable for? What's the amount of money T3 is liable for? Now, it's not big math. It's not going to be little fractions, but common sense tells you that if it's $10,000 a year, and T is liable for what? $5,000, correct? $5,000. If the landlord gets from T1 $1,000, right? How much is T liable for? $4,000. If the landlord gets $20,000 from T2, right? How much is so each? You understand what I'm saying? So that kind of math does exist, and be prepared because you get that. It's not the numbers; it's the understanding about privity of estate. Privity of estate. So far, so good. The same thing happens in T3. Moves in for the last year. What happens to T2? Once the assignment is there, T2 is out of the picture. Correct? T2 is only that. Now, let's go back to a sublease and simplify it. Remember that a sublease, correct, is not in privity of contract. However, if the subleasee in writing decides to assume the liability of T, T1 assumes the responsibility. T1 is a subleasee which assumes the responsibility to the landlord for the payment of the monthly rent in writing. Okay? Now, T1 is going to be liable for the money. But that doesn't create privity of estate. That doesn't create privity of contract. The assumption of that debt makes him a third-party beneficiary to the agreement between these two. These two had agreed to let him use the property, right? For a certain, and this one owes the money technically to him, right? So between these two, there is a contract, but not between these two. I just want to make sure you understand that T1, if it's a subleasee, is liable to the landlord when he assumes the debt, not because he now becomes, he gets privity of estate. He doesn't. He doesn't have any privity of estate. He doesn't run with the land. That's why he has to do what? That's why he has to assume it, because he doesn't run with the land. Under the lease between T and T1, he doesn't have to, technically, the only one he has to pay money to is T, not landlord. He has got no responsibility to the landlord because he doesn't run with the land. So he doesn't, by assuming that responsibility in writing, he doesn't get privity of estate or gets privity of contract. He's not negotiating with the landlord. He's negotiating with T. So if that's true, how in the heck does he become liable? As the fiction of a third-party beneficiary. Now we know, to complicate it, if on the third-party beneficiary, he was simply a donee, if it was a gift, it wasn't intended to benefit, but it was a gift, right? He didn't pay money for it, he's not liable even on the third-party beneficiary. Remember? Have you done third-party beneficiary stuff? Yeah. Remember the whole distinction of donee, and now there's no distinction, is intended versus not intended? Do I remember this right? All right. Everybody clear about that? Everybody clear about this? Before you ask the question, because I don't want to confuse it anymore. Okay. Now, if he's a sublessee, let's just do this. He assumed the responsibility, and now he assigns it to T2. He's still liable for the time he was there. You understand? Once he assumed it. All right, what's your question, sir?
Okay, so under the assignment, T and T1 still have a relationship of contract, of privilege of contract under the assignments between T and T1.
Sure, but you're complicating more than you need to.
Okay.
Let's just be concerned about the relationship between landlord and tenant. Obviously, these two enter into a contract, right? Obviously, tenant said, I enter into an agreement with you that you would move into my property and pay the rent for the next 4 years. Obviously, that's a contract, right? So don't complicate it any more than that, because then it confuses it. Obviously, there is privilege of contract between these two, right? And once he assigned it to this, there's no privilege of contract. So as far as this one is concerned, right? He owes money, and and he owes money to this one too, but he also owes money to. Now, there was in the old days a thing called the landlord had to go, and you see some of the commercial outlines. The landlord was supposed to go first to him, and then if he didn't get the money, then he would go to him. Right? That's not the case anymore. Landlord can go to either one. Right? And you have some problems, and you can see this. Now, let's finish this by the question that was asked, which is important. How about a lease that says assignment, you cannot assign, or a sublet? How about the difference between a commercial and a residential area? The lease may contain a clause that says landlord may not assign, tenant may not assign or sublet. Correct? May not assign or sublet. As far as residential premises are concerned, the landlord may deny the permission. If it doesn't say without permission from the landlord, if all it says is tenant may not assign or sublet, right? If the tenant assigns or sublets, the tenant is the assignment or the sublease is valid, but the tenant remains liable for the damages. If it doesn't say anything except you cannot assign or sublet. If it says you cannot assign or sublet without permission from the landlord. Without permission from the landlord. In that case, the transaction between the tenant and the assignee or sublessee is voidable. It's not void. That means that sublessee or that assignee can remain in that property legally until the landlord evicts them. And the landlord can evict them. You understand what I just said? That's only when it says you cannot assign or sublet without permission of the landlord. Not one of the leases that you wrote, not one, didn't have that. A landlord can deny permission to assign or sublet for any reason, good reason, bad reason, no reason at all, in residential premises. As long as it's not discriminatory and as long as it doesn't violate the law. That's not the same on a commercial setting. On a commercial setting, the landlord can only deny permission to assign or sublet when it is called commercially reasonable. We know that the desire by the landlord to get more rent is not commercially reasonable. It has to be that there's going to be a change in the nature of the commercial place that's going to affect the commercial, that there's something illegal that's going to go on. Those are the things the landlord can use, commercially reasonable. Everybody clear about that?
I just need you to repeat that one time for me. You said if it says you can't sublet or assign, then it's voidable?
If he says
I mean,
you
it's void.
no, it's not. If he says you cannot assign or sublet, that's all he says. If the tenant assigns or sublet, that's a valid. It's not void or voidable.
Okay.
The landlord cannot evict that person.
Okay.
All he can do is sue the tenant for damages. Right? So, but if he says you cannot sublet or assign without permission from the landlord, now it's voidable at the choice of the landlord. The landlord can decide, okay, everything is fine, I'm going to let you stay there. Now, here is a problem. Once the landlord says, if he says do not assign or sublet, once the landlord allows it, he's barred from ever again denying it. Right? So it seems like tomorrow we're going to have to do concurrent ownership. Is it helpful today again?
Yes.
And I made it through without throwing a temper tantrum. So. Thank you for coming this morning.